So what is mediation? So either you or your spouse has filed for divorce. You may have had a hearing or two, had some discovery, had a deposition, and you're wondering, how does my case get resolved? Well, it's going to get resolved one of two ways, because it will get resolved. One is through an agreement that you reach with your spouse. The other is through a trial. And mediation is the process by which you reach an agreement with your spouse. It's one of the processes. And it's a confidential process, which means that anything that is said during those negotiations is privileged, meaning that if you make an offer to your spouse and they don't accept it, and the case goes to trial, you don't have to worry about your spouse saying, well, he or she said that she would give me this or she would give me that. You're able to make offers without having them be used against you later on. So you're able to compromise completely without having to worry about that being used against you. So what should you consider when you're choosing a mediator? Obviously, finances are a big reason that you should be considering. How much do you want to spend? How much do you have available to spend? Is this something that's going to be paid by you, or is it going to be something that's going to be split with your spouse? Obviously, the cost of the mediation is going to be one of the big factors. The second is, what type of mediator do you want? I think that for purposes of choosing a mediator, this is probably the most important thing. That is, you're either going to have a retired judge, or you're going to have an experienced attorney that is skilled in mediation services. You're going to be looking at this from either, or you want a retired judge, someone that's been on the bench for 5, 10, 15, sometimes 20 years, and is going to have the experience of hearing hundreds, if not thousands, of cases very similar to yours, and they can give you the unique perspective of what a judge in your case is going to see if the case goes to trial. Keeping in mind, if you have an attorney or the other side has an attorney, you already have your cheerleader. But the mediator, especially a retired judge, is going to give you the unique perspective of someone that doesn't know your case and is going to hear it in a very short period of time. And that can be very useful and very valuable when you're determining what you should be compromising on and how much you should be compromising. The other is, if you use an experienced attorney, it's the same thing, but you're getting the perspective of someone that is currently litigating or has been litigating, and they don't have the perspective of having to make those decisions in hundreds of cases similar to yours, where they've only seen the case for maybe a day or 2 days. So you're probably wondering, how do you know if you and your spouse are good candidates for mediation? Well, the good news is that everybody is a good candidate for mediation. The question is whether or not you will come to mediation with an open mind and with a desire to actually resolve your case. That will make you a better candidate for mediation at the time of your mediation. So what I would suggest is that whether you have what's called a mandatory settlement conference or you actually have mediation, that you prepare for that mediation, understand your case, understand what your evidence is, and also go into it with an open mind and open ears and do a lot of listening. Because ultimately, you may be aware of things that are beyond the evidence and beyond some of the issues that are very important to you, and the mediation process allows you to address those things that are most important to you. So come to mediation with open ears and an open mind, and you'll have the best opportunity for success. So what if you and your spouse both have attorneys, and your attorneys are both settlement-minded? Do you need a mediator? In my opinion, I think a mediator is always a positive addition to the mediation and settlement process. And the reason being is this. Your attorneys can send settlement offers back and forth, and that takes time. And unfortunately, when it comes to settlement, from most parties' experiences, time is not something that they enjoy, and it's not one of their friends. When they're in a settlement mode or they're settlement minded, they want to get resolution as quickly as possible. And sometimes just having the snail mail or the emails between attorneys doesn't play well into the time frame. Having a mediator is going to allow you to schedule a mediation session, which means that you, your attorney, your spouse, and your spouse's attorney have committed to setting aside a half a day or a day to focus specifically on resolving the case. So instead of having emails or letters go back and forth, you've now committed to a space and time to get your case finished. If both attorneys are settlement-minded and both parties are settlement-minded, this is an optimum use of your time and space. It also means that you and your spouse will be in the same location, maybe not the same room, but you'll be on the same floor, for example, if you use private judge's services. And what will happen then is that once you've narrowed down and you use the opportunity to settle all the issues and you know what those settlements are, that retired judge or that private mediator is going to write everything up and the parties will review it and sign it that day and you will be finished. So while it may be a little bit less expensive to have the attorneys go back and forth, there is certainty, especially with settlement-minded attorneys and settlement-minded parties, that when you use a private mediator, you have the certainty that when you are finished with that half day or day, your case is finished.